When we talk about minimum contacts, what we mean is that a party must have certain contacts with the state such that that party could reasonably expect to be brought into court in that particular state. So minimum contacts is a term used throughout the United States judicial system, and it is used to determine when it's appropriate for a court to exercise jurisdiction over a defendant from another state or from another country. Now, what the United States Supreme Court has said is that it is unfair to assert jurisdiction over a party unless that party had such contacts that it could reasonably expect to be brought into court in that state. And this exercise of jurisdiction is limited by concepts of fair play and substantial justice. Let's talk about a case. There's a case called Asahi Metal Industries versus Superior Court of California. This is the definitive case on minimum contacts. Now, this case concerned a Japanese company, a Japanese corporation that manufactured valve stems. The valve stems that were then later used by tire manufacturers. Well, a shipment of Asahi valve stems was sent to Taiwan, where those stems were used in the creation of motorcycle tires by a Chinese corporation. Those motorcycle tires were later purchased by a California resident, and at some point there was an automobile accident, and it was alleged that the Asahi valve had failed. So the plaintiff, the motorcycle rider, sued Asahi in California court. And the question was, did Asahi do anything to indicate that it expected to be brought into court, that it could reasonably expect to be brought into court into California? Now, the Superior Court of California said yes, and they based this fact on that once a corporation puts a product into the stream of commerce, in this case that was Asahi selling the product to the Taiwanese corporation, once it enters into the stream of commerce, then a company should expect that wherever that particular item ends up, that could be where the corporation could be called into court. This is a very broad reading of minimum contacts because it says if you sell something and that product winds up somewhere far, far away, remember this was the original sale was from Japan to Taiwan, and the case was brought in California. So this is a very broad reading of minimum contacts. Well, the Supreme Court said no, that's too broad. And so the Supreme Court developed a test, a 5-factor test, in order to determine whether minimum contacts were sufficient, whether there were enough so as to not offend traditional notions of fair play and substantial justice. And I've got these in your lecture notes, but I'll go over them right now. And what they do is look at these various factors and then perform an analysis and eventually draw a conclusion. And the first factor is, what is the burden on the defendant? What is the burden on the defendant? Now, in this case, a Japanese company is ordered into a California court. That's a pretty substantial burden. The litigation is going to be happening thousands of miles away from Japan in a different language. This Japanese company is going to have to retain California lawyers. It's going to have to retain Japanese lawyers. It's going to have to appear in court in California. It's a very heavy burden on the defendant. Now, the next thing they look at is, what is the interest of the forum state? What is the state's interest? And again, in Asahi, well, the state has a pretty strong interest in that the state of California has an interest in regulation of motorcycle tires sold in California, then used in California, and the failure of which injures a California resident. So in Asahi, you could say that there was a pretty strong interest in the forum state in the litigation. What's the interest of the plaintiff in litigating the matter in that state? Well, this is slightly less convincing. In this case, the plaintiff obviously has a strong interest in litigating the suit, and it would be much to the plaintiff's benefit to litigate that suit in California as opposed to having to go to Japan. So it cuts that way, but in fact, he could go to Japan. There's nothing stopping the California resident from filing a lawsuit in Japan. The fourth question is, does jurisdiction serve interstate efficiency? Would it promote efficiency to hear the case in one court as opposed to another court? If, in this case, the California court is going to hear not only a claim against Asahi, but also against the motorcycle tire manufacturer, also a claim against the opposing driver who injured him, well then maybe it would be more efficient to all hear that in one court rather than having a Japanese court having to decide one issue while all the other issues are decided in California. And finally, policy interest. Would the exercise of jurisdiction serve interstate policy interest? And this can cut both ways. Nevertheless, in our situation, or in the case of Asahi, the court found that there was not enough, weighing all the factors together, there was not enough to expect the Japanese corporation to expect to be hailed into court in California. The next topic related to choice of forum, where the case is going to be heard, we're going to look at is the question of venue. Now, venue is somewhat related, or sounds like jurisdiction, in terms of it being about where a dispute should be heard, but it's a different concept. It's a much more flexible concept than jurisdiction. Jurisdiction either exists or it does not. Venue, however, can exist in multiple courts, and it could be a matter of what is the most appropriate court. And when we're talking about venue, we're talking about geography, the geographical location. What's the proper geographical location for the suit, for the lawsuit to be heard? And that question of proper geographical location can differ depending on the type of dispute. For instance, in a contract dispute, venue would relate to where was the contract negotiated? Where were the terms decided? Where was the contract to be performed? Which venue would have a greater relationship to that contract? So in terms of contractual venue proceedings, it tends to be along the lines of what does the contract say? Well, what were the circumstances of the execution of the contract? On the other side, for instance, in a tort, in a personal injury claim, proper venue is usually where the accident occurred, where the harm occurred is generally held to be the proper geographic location. So in a tort arising out of a helicopter that crashes into the sea, wherever the helicopter crashed should yield the proper venue. Even if the helicopter was manufactured far, far away from the site of the eventual crash, the location of the geographical location of the injury is the most important. Not to say that one could not make an argument for another geographical location, because as I said, venue is flexible. Venue can even be agreed upon if two companies would prefer to litigate a suit in one venue as opposed to a more appropriate venue elsewhere. the court should respect their opinion and their choice of a forum.